It's been a pleasure to meet George. I think he's the best advocate opponent I've ever had. And it's been a pleasure to meet the students and talk with students. I was very, very impressed with the students today. Anyway, tonight in the few minutes that I have, before I tell you why I think that the opinion by Chief Justice Roberts was the correct opinion, first I want to explain what the opinion said. One of the things I realized, because I've talked about the Affordable Care Act a lot, is that people have a lot of misconceptions about what the opinion actually said and what and why was upheld. When the opinion came out on June 28th, it was one of the most anticipated Supreme Court opinions. The Supreme Court's website had to put up extra servers, and there were 5 million downloads of the opinion as soon as it came out. Even the announcement about the opinion was controversial. If you were watching CNN and a few other of the stations, you probably heard that first they said the individual mandate was unconstitutional, and then moments later they had to come back and say, no, it's constitutional. So this opinion from the very beginning has been very controversial. In fact, the bill itself, from the moment it passed or during the time it was being considered, was controversial. It remains so. The opinion has, not the opinion, the act has over 900 pages with hundreds of regulations. Most of the legislators didn't read it before they voted on it, which is not unusual. A lot of times it's the civil servants that do all that. Moments after it was passed into law signed by President Obama, there was a lawsuit that was filed in the Northern District of Florida by 12 states. And so then it came to the Supreme Court on a grant of certiorari, which means the Supreme Court had discretionary review. There were 4 Circuit Court of Appeals cases that heard the various issues on the Affordable Care Act. 2 of the circuit courts, the 6th and the D.C. Circuit, found the individual mandate constitutional. The 11th Circuit found it unconstitutional, and the 4th Circuit found that the Anti-Injunction Act passed, meaning that if the mandate was a tax, there's a statute that says nobody can contest the tax or challenge the tax until it's paid, and the mandate doesn't go into effect until 2014. So if the Anti-Injunction Act applied, the case would not be ripe for review to decide merits of the case. Anyway, it came to the U.S. Supreme Court. The U.S. Supreme Court addressed 3 issues. 1, whether the Anti-Injunction Act applied, and therefore the ruling on the merits would not be right. 2, whether or not the individual mandate was a valid exercise of Congress's constitutional powers. The individual mandate, many of you probably know, is a penalty or a tax that is imposed on uninsured people that are not exempt under the Act, who can afford to buy and maintain insurance and are uninsured. The tax or the penalty basically is for an individual $695 or 2.5% of the household income, whichever one is the greatest. That is the bottom of what someone would pay with a penalty, and it's capped out at whatever the cost of a yearly annual premium would be for an insurance plan that covers 60% of the cost. So anyway, the individual mandate was the provision that created probably the most controversy. And the purpose of making people who did not have insurance but could buy insurance especially for young people who are healthy and probably won't be using much medical care, was to provide cost shifting, because the problem was there were, in the year of 2008, there were $43 billion of uncompensated medical services. And this cost shifting problem, if people didn't pay for the services, then it was incumbent on those of us who had insurance to pay for it. And the cost shifting resulted in an increase, an annual increase of $1,000 a year for family premiums. The third issue was whether or not the Medicaid expansion provision was constitutional. So there really was only two provisions of the whole act that was considered by the Supreme Court. First, the Anti-Injunction Act. Neither party who finally got to the Supreme Court argued that the Anti-Injunction Act actually applied, so the Supreme Court appointed counsel to brief and argue that issue. Now, this probably is the most troublesome of the opinion for Chief Justice Roberts, because what Chief Justice Roberts said is that the individual mandate was not a tax for purposes of the Anti-Injunction Act, but it is a tax for constitutional purposes. And saying that, it's a little bit like wizardry. I think Justice Scalia actually said that. So I think that's the part of the opinion that gets people a little confused. I'm just going to say that what Chief Justice Roberts explained, that whether or not the Anti-Injunction Act passed was however Congress created the statute. And in the statute, the Congress did call it a penalty. There were numerous places throughout the 900+ pages of the Act that basically talked about other financial exactions and called it a tax. So according to Chief Justice Roberts, if the statute that Congress created called it a penalty and did not provide a provision for the Anti-Injunction Act to apply, then it did not apply. So then how do we get to the 8 minutes already? How did we get to the fact of it being a tax for purposes of it being constitutional? Well, I'm sure my opponent's going to talk about the Commerce Clause. As many of you know, Congress and the President said that they were enacting this pursuant to the Commerce Clause. The big issue, Commerce Clause provides express power for Congress to regulate commerce amongst the states. And the whole issue was, well, how can Congress compel people to get into a commercial market? So the concern was compelling inactivity. So Chief Justice Roberts said, okay, it's not a valid exercise of the Commerce Clause, but it is for purpose of the taxing clause. Now, how can it be a tax for purposes of the constitutional purposes and not for the other? There is precedent. Despite the fact that Justice Scalia in his dissent said there was no precedent to call a penalty a tax, there was precedent to call a tax a penalty. And I will explain. There was, in the 1920s, the child labor tax law. The Congress called that a tax. For purposes of the Anti-Injunction Act, it applied, and the case could not be heard on the merits until after the tax was paid. When it came to the Supreme Court on whether or not it was a valid exercise of Congress's taxing power, the court said, no, this is not a tax, it's a penalty. It was a penalty because it imposed a very deep 10% of net income of an employer who hired children as employees, whether the violation was one child, one time in the year, or several children every day of the year. So the penalty was not proportioned to the violation of the statute. Further, it really was, in order to be taxed under the Child Labor Tax Act, the employer had to know that they were violating the act. That's called scienter. So very often times when a statute requires scienter, then we're talking about criminal and punishment. Third, the collection of the tax was not only through the Treasury Department, but it was through the Department of Labor. And the Department of Labor could come and make inspections to the employer's place of business at any time. Well, if the Department of Labor is the agency that protects the welfare of workers, so it was clear that this was a penalty for hiring children. So in applying this analysis to the individual mandate, Chief Justice Roberts said, it is nothing like the tax in the Child Labor Tax Act that the Supreme Court said was a penalty. In essence, the only consequence of not purchasing assurance is to pay the tax. But the Act specifically says that none of the enforcement mechanisms that are available to the IRS to collect an unpaid tax are available to enforce the individual mandate. So there's no criminal liability for not paying the tax. IRS can't garnish wages, can't put a levy on the home. So because of this, Chief Justice Roberts said it was a tax. But what's really important is Chief Justice Roberts was true to his conservative view, although he did agree with the 4 liberal justices. Chief Justice Roberts is all about judicial restraint. And this opinion, by saying that it was constitutional, upheld one of the basic principles of judicial review. And that is, if a statute can be read in one of 2 ways, then it must be read in a way that keeps it constitutional. That shows deference to Congress and Congress's ability to make policy. So I just want to say, my time is almost up, but Chief Justice Roberts said over and over again in his opinion that the policy judgment about the wisdom of the Affordable Care Act is for the elected leaders. It isn't for the court to decide the policy. He specifically said it is not our job to protect the people from the consequences of their political choice.
Well, thanks to everyone for coming this evening. Thanks to Professor Murray for setting up this debate, inviting me. Came and spoke at Constitution Day last year. Was delighted to have that opportunity and glad to be back. And 2 thumbs up to Weber for the series of debates on important topics of public policy. And thanks also to Terri for clearly explaining what the Supreme Court actually did in the NFIB versus Felia's decision a few months ago. I'm going to try to explain to you why I think the Supreme Court blew it, why the entire legislation is flagrantly unconstitutional. And to get to my conclusion, I'll start with a bit of history. As he was walking out of Independence Hall in Philadelphia after the drafting of the Constitution was finished, a woman came up to Ben Franklin and asked him, Dr. Franklin, what manner of government are we to have? And his reply was, a republic, madam, if you can keep it. He was skeptical about our ability to keep government within bounds, but famous quotation. Well, now let us imagine that the woman had continued asking him and had said to him, well, Dr. Franklin, does this mean that this new government we are to have is entrusted to guarantee us our health care? Well, he certainly would have replied something like this. He would have said, no, madam, it is not the job of the government to guarantee you your health care any more than it is to guarantee you your food, your your shelter, your clothing, your education, religion, or anything else. These are simply not functions we believe belong to the central government. In other words, he would have said, no, this is not a proper function. Now, Franklin and the other founders had lived for quite a few decades, from about 1760 up to 1775, when the rebellion broke out, under a government that was increasingly hostile to their rights and liberties. The English Parliament and King George passed one law after another that restricted their freedoms, infringed upon their rights as Englishmen, took their money away from them for purposes they did not approve of, taxation of representation. They were sick of it. All of this hit so quickly that they didn't have time to adjust, to think, oh, you know, this government it's not that bad. They rebelled. They were in open rebellion by 1765 with the Stamp Act. They did not want the kind of government they had lived under the King and Parliament. That's why they wrote the Constitution the way they did, putting strict limits on what government could do to the people. Some famous quotations from the founders about government are very illustrative here. First of all, George Washington at one point wrote, "Government is not reason, it is not eloquence, government is force. Like fire, it is a fearful master, and it is a fearful servant and a terrible master." Thomas Jefferson wrote that the function of the Constitution was to bind down the powers of government with chains. James Madison, who was widely regarded as the father of the Constitution, wrote that it was important that we enumerate specifically the powers government was to have, and otherwise leave the people alone. That's the point of the 10th Amendment. Only those powers which were expressly given to the federal government belong there. Everything else is left to the states or the people. They feared a powerful central government and gave it only a few specific powers. And I think these men were very realistic in their understanding about the danger of government to people's freedom, to their property, to their individuality. They had seen what unlimited government could do, and they wanted to make sure we didn't have that. Now, I have a copy of the Constitution here. It's not very long. I recommend that you read it. The powers that were given to Congress are in Article 1, Section 8. No place in here, and this is the point of my hypothetical questioning of Ben Franklin, does it say anything about the federal government controlling medical care, health care. It says nothing about that whatsoever. It's not an enumerated power. The founders would have left this up to state control, if at all, or up to the freedom of the people to make their own health care arrangements. They certainly would have said, if you could have asked them, like Ben Franklin, should the government be doing anything? Does the federal government have any proper role to play in determining how we will have health care in this country? They would have said, no, that belongs elsewhere. Now that brings me to the decision in the case. By the way, there is still litigation out there against the Affordable Care Act, or as I usually call it, Obamacare. There is a case challenging the constitutionality of the Independent Payment Advisory Board, which one writer I respect has said the most flagrantly unconstitutional part of the whole thing. It sets up a bureaucracy which cannot even be overridden by Congress. Astounding. Certainly Madison and his fellow founders would have said unbelievably unconstitutional. You can't do that. That litigation is still out there. But just focusing on Robert's decision, first of all, I think he was right in saying this mandate cannot be justified under the Commerce Clause. The Commerce Clause says Congress has the power to regulate commerce among the several states. What the word regulate meant in 1789 was to keep regular, to prevent obstruction to. What they were aiming at is state legislation that would inhibit trade across borders, putting tariffs or barriers up against goods coming in from other states. They wanted to stop that. It did not mean to give Congress blanket power to regulate anything having to do with business whatsoever if it had some interstate connection. That's not what they meant. At least Roberts got that right in saying, no, we can't justify this mandate that way. He was wrong, however, first of all, in upholding the entire idea of federal control, the politicization under federal bureaucracy of health care. As I just said, there's nothing in Article 1, Section 8 that gives Congress any authority whatsoever over health care, medical care, insurance. He was also wrong in using his Solomonic let's split the baby in half reasoning with respect to the taxing power. This is not the first time this has been done, by the way, that in order to do something which has no constitutional basis, the Congress has resorted to the taxing power. They did it with respect to Social Security back in 1935. They whispered in the ear of the Supreme Court justices, it's okay because it's a tax and we have plenary power to tax. Here's my argument against that. Congress should no more be allowed to accomplish unconstitutional ends through unconstitutional means than it should be allowed to ignore the Constitution at all. Consider this. If Congress can give itself new powers just by taxing, why can't it not use the same power of taxing to accomplish other ends that were flagrantly undermine the Constitution? What if, for instance, we passed a law and it said there will be a tax upon members of the following churches, $10,000 per head, tax if you're a member of any of these churches. But the tax will be only $1 if you're a member of the church we happen to approve of. Now, you might say, well, that's a demolition of the First Amendment, right to freedom of religion. Oh, but wait a minute. It's not establishing religion. It's just a tax. Some people pay more, other people pay less. If you allow the government to use the taxing power to undermine the rest of the Constitution, we may as well forget about this little document. There's almost nothing that you cannot rewrite or undermine by using taxes. So that's why I think the Roberts decision is wrong. They have no business regulating health care whatsoever. And this business about saying, well, it's okay if you do it through the taxing power, undermines, or can be used to undermine, all the rest of the Constitution. So, it's a bad decision. First of all, because it expands federal power where none is authorized. And second, because it opens up a Pandora's box to future expansions by the use of taxation to accomplish ends that are not within the Constitution. We should not allow the Congress to use constitutional means to accomplish unconstitutional ends. So that takes me back to Ben Franklin. We're much closer today to the kind of arrogant, overweening, rights-destroying government that he rebelled against under the British Crown than we are to the sort of limited, rights-protecting government that he, Madison, Jefferson, Washington meant to set up under the Constitution. So that's my case against the Obamacare decision.
Earlier today, George and I met with Professor Murray's class, and we talked about originalism versus a more progressive view of the Constitution. The difference between George's and my perspective is that, of course, the Constitution doesn't say anything about regulating insurance, but, you know, the Constitution doesn't say a lot of things. In my perspective, the Constitution is a living, breathing document that must keep pace with the times and the problems that Americans face. And because it is such a small document, it requires the court to read into implied powers. Now, George says that if they could tax not getting health insurance, that they could tax churches. Absolutely not. That would be a violation of the First Amendment. That would be a violation of free exercise. Even Justice Scalia agrees that Congress could have used its taxing power to enact the individual mandate. The only difference between Chief Justice Roberts and Justice Scalia is that Chief Justice Roberts was willing to interpret it in a way that was constitutional. Chief Justice Roberts said, well, if they said it was a penalty, it is a penalty. They should have said it was a tax. Then it would have been constitutional. So Chief Justice Roberts was saying, if it walks like a duck, if it quacks like a duck, it is a duck. It's a tax. And taxing, we get taxed for a lot of things. And yes, Congress can use its taxing power to influence behavior. It does it all the time. But it can use the taxing power to get at certain issues that it could not regulate directly through the Commerce Clause. There's a very important part of the decision that was not upheld, and that was the Medicaid expansion provision. Chief Justice Roberts, along with 6 other justices, agreed that it violated the 10th Amendment, forcing the states to accept Medicaid funds from the federal government and then create this massive program was a violation of state sovereignty. So, yes, Chief Justice Roberts' opinion was somewhat of a compromise. He reined in Commerce Clause powers. He upheld the central idea that the federal government is a government of limited powers by not saying that Commerce Clause could regulate inactivity. He respected states' rights by saying that the Medicaid expansion provision was unconstitutional. And most important, he left it to the people. This is an election year. Chief Justice Roberts says, it's not for us to protect you from your representatives. It's up to the people. In upholding the mandate, even if it's very flawed, it resulted in decades of discussion, starting with the Nixon presidency, on the nation's insurance system for health care, a problem that leaves 50 million uninsured Americans and costs $2.5 trillion, which is 17% of the national economy. Chief Justice did the right thing. And also, he preserved the integrity of the court. He showed that at least one branch of the government could operate without gridlock. And I respect Chief Justice Roberts for his opinion.
Well, I knew we'd come back to the discussion we had earlier today about the meaning of the Constitution, whether it needs to keep pace with the times or not. We had a debate in Professor Murray's class earlier today over that. Wish we could have a video of that right now. I don't know if we can do that. Let me respond to several of the points that Terri made. First of all, she praises the Chief Justice's opinion because it showed judicial restraint, and she thinks that that's a good thing. I don't. I don't think it's a good thing for the court to be restrained when it should be protecting people's rights. No one would say it would be a good thing if the court said, well, we're just going to let the people sort things out. If Congress passed a law establishing a national church, we wouldn't say that it was okay, we'll just let the people sort that out in the next election. Or if we pass a law reinstituting slavery, or the same thing as far as I'm concerned, the military draft. Would we just say, well, the Constitution says involuntary servitude's out, but who are we to judge the wisdom of that? we're just going to defer to the legislature. It's the job of the justices to uphold the Constitution. Whether you think it's basically a good policy or a bad policy, if it is not inside the Constitution and interferes with people's rights, which I maintain is the case here. I know people who don't want to have to buy health insurance and don't want to be penalized for not wanting to buy it. And nevertheless, they're going to be treated like those members of the citizens in Pennsylvania or Massachusetts who were compelled by the British government to buy stamped paper. Actually, this is worse. If you didn't want to buy stamped paper, if you didn't want to buy paper, you didn't buy stamped paper. Here, if you don't want to buy health insurance, you're going to be penalized anyway. This is a violation of people's rights. It's the job of the court to stand up and protect our rights, and they didn't do it. Secondly, we have this important debate over whether the Constitution needs to change with the times. I maintain that it does not need to change with the times, unless the people go ahead and amend it, which they are perfectly free to do and have done quite a few times. If people really think we want the federal government overseeing our health care, I would love for the people who believe that to draft an amendment which would then be debated throughout the nation, and people can think about the pros and cons of what we're doing. That would be infinitely better than a few members of the Supreme Court, judges with lifetime tenure, who really don't understand much about the pros and cons of public policy, making this decision for us. Furthermore, how is the Constitution supposed to change with the times? Is there any agreement amongst Americans as to exactly what the Constitution should now mean that it didn't mean in 1787? Terri and I have a significant difference in agreements in at least some things about the Constitution. I think it gives too much power. She thinks the government needs more power. We don't agree on that, so why should 5 justices make that decision? Shouldn't we have a national debate? If we're really going to change the meaning of the Constitution, let's have an amendment. That's why they put the amendment process in there. We should use it.
Whenever it comes to legislation, what I'm wondering about is how did the court throw out part of the law, the Medicaid expansion provision, and not throw out the whole law in the absence of a severability clause?
Well, they didn't completely throw it out. They said it couldn't be mandatory, so it's voluntary. I mean, if the states want to accept the federal funds and expand Medicaid to citizens, it's expanding Medicaid to citizens who are 133% over the poverty level and who don't have third-party no employer payment and can't afford self-insurance. So, you know, it really, let me say this, nobody knows how this is going to actually be totally enforced. There are hundreds and hundreds and hundreds of provisions in the bill. There are 10 titles. Title 10 had to do with, Title 10 had to do with the amendment process, and Title 9 had to do with the finances of this. Nobody knows where the money's coming from to enact all this. So, in many ways, it is a very flawed statute. It is an idea in progress. We haven't heard the last of health care, no matter who gets into office.
Very good question. I think the only answer is this was a political decision rather than a legal decision, and the Chief Justice, along with his 4 collaborators on the liberal side of the court, wanted the case to turn out this way, and that's why they turned the blind eye to the lack of severability. Justices can do what they want to do, and this is the case where they did it.
So this idea in progress that's now the law of the land and is affecting business decisions every day, we didn't have a severability clause, so in the absence of severing a part of the law, the Supreme Court chose to rewrite the law, which would be the business of Congress. We've also got an individual mandate that was determined to be a tax that originated in the Senate when all tax law has to originate in the House, where we get to chop at those folks every 2 years. Now we've got a law written by the Supreme Court, and we don't get to chop at those folks. Comments?
Good point.
Well,
One more of the things that they just decide, well, we're going to turn a blind eye to that inconvenient fact about tax legislation having to originate in the House.
that goes to the heart of the problem. But I maintain that Chief Justice Roberts and the 4 justices that upheld the individual mandate did not do it willy-nilly. There was precedent for them to do it. Again, Justice Scalia, who wrote the dissent, and 4 of the justices agreed with the dissent, said that Congress could have done the individual mandate through the taxing power. So the difference is, Chief Justice Roberts said, I'm going to call this what it is. Again, if it walks like a duck, if it quacks like a duck, it is a duck. There is precedent to do that. There is no magic in the words that Congress uses. And yes, it's for Congress in the first instance to decide the constitutionality of their statutes, but ultimately it's up to the Supreme Court, and that's what they did. And it's interesting that the 4 dissenting justices would have upheld it if Congress had said it was a tax.
Thank you, Phil. The court would have upheld it if it was a tax. I think if it was a tax, the people who had the opportunity to vote for their House of Representatives, the representatives in the House, of course, we get that opportunity every 2 years, because if they impose a tax on us that we don't like, I mean, this was one of the founding portions of the Constitution. This was critical. If it was a tax, they'd have called it a tax, even though we weren't going to get to see what was in the bill until after it was passed. It was passed before 2010 came along, and we could, or before the election in 2010 came along, we would have had our opportunity to act on folks who imposed a tax. So the terminology really is important. It really is key. And getting passed as a penalty kept the voters from acting and responding to the situation as we were given the opportunity to act in the Constitution. Comment?
You have another chance in a month.
Yeah, decisions are being made right now, and they've been being made for 2 years
I know they
with
are.
this law.
I know they are, but the penalty provision doesn't go into effect until 2014.
And the business
And by the
outlook for the
way-
people making these decisions is much longer than that.
And by the way, it is probably cheaper for people who are healthy and don't need insurance to pay the penalty than to pay a premium and get insurance. So
Back to the question about the law originating in the Senate, there's still a loss as to how determining that it was a tax, it then wasn't determined to be constitutional because of its point of origin.
nobody raised that. That was not argued.
Thank you.
You have a good future ahead of you if you want to become a member of the bar of the Supreme Court.
I have no future. I'm already there.
You said that you won't be criminalized if you don't pay the tax. What exactly will happen if you don't pay the tax? If you can choose not to pay it?
The only thing is if you file a tax return and you get refund, that the penalty or the tax will be deducted from your refund, and that is the only consequence. So for people who don't file income taxes or aren't going to get a refund, there's nothing that the IRS can do.
So basically, if you don't file taxes and you don't pay the tax, you can just escape the bill.
Well, at some point, I hope you're going to make enough money to pay income tax. I mean, you have to pay income tax. But, you know, if you are violating the obligation to pay income tax, that's a separate obligation you have under law. But there's nothing, if you don't pay the penalty, that the government can do in terms of punishing you criminally, or, like I say, putting levies on property, or garnishing wages, or any of the mechanisms that the Internal Revenue Service can use to collect taxes.
I'd like to ask a question about a statement I believe I heard about a living, breathing document of the Constitution. I have always believed there are certain inalienable rights.
Oh, absolutely.
And I'm just wondering, what do you actually mean
Okay.
by calling it
Yeah.
a changeable document at any time?
No, I don't mean it's a changeable document at any time. Yes, there are inalienable rights, and some of those are not expressed in the Constitution. All I'm saying is that it's a very well-accepted view of constitutional decision-making, which is called the non-originalist or the progressive view, that what the intentions of the framers were in 1787 don't apply today. First of all, people didn't live as long as we do today. Who thought about health insurance? There wasn't health insurance. They probably went out in the fields and they died. But I'm being a little facetious. But nobody anticipated that we would be living to, 85, 90, 100 years old. As I said today in the class, there are a lot of things in the Constitution, even if they're written in the Constitution, the language is very open. So what does equal protection under the law mean? If we went with what the framers of the 14th Amendment meant at the time when they passed and ratified the 14th Amendment, they didn't mean equality for women, not at all. And so my point, along with people who believe that the document should be read with modern values, is that we have to keep up with modern society.
If I could respond. We had a very engaging discussion the other day where I found out that Terri doesn't believe in this living constitution theory as to the parts where she likes what it says. Specifically the First Amendment. She's not at all. We are in complete agreement that the First Amendment, prohibition against laws that infringe upon the freedom of speech or the press or establish a religion, they should stay exactly as they are. What the progressives have always wanted is to reinterpret the parts of the Constitution where they want their view right now. They don't want to listen to other people's views as to what the times might call for. They want their view written into the Constitution by de facto amendment by the Supreme Court. Here's the problem. Americans don't agree as to what the times call for. Some people think the times call for a vast federalization of the entire healthcare market. What I think the times call for is a depoliticization of the healthcare market. We all wind up with much better, lower cost care if we got the government out of health insurance. Now, who should prevail as to what the times call for? That's why we have the amendment process. If we think the Constitution does not say what we'd like it to say and does not confer the powers, or maybe it confers too much power, amend it. That's the difference. The progressives want to get their way without going through the amendment process, and they've succeeded in that over and over again. I think it's time that it stopped.
Any other questions? I'll ask one. You can both respond. My question is, is there another example where the government is taxing people for not doing something?
Property taxes. Whether you own property or not, you pay them. If you rent, their part, you know, your rent is consistent with whatever taxes the landlord, with whatever taxes the landlord pays. So, you know, that's one.
But that's not federal.
Well, but that's not constitutional. That's local. I can't think of a good example, but I know what you're driving at is, does commerce call for us to actually do something before we can be subject to any regulation by the government? And I think that it does. If you could have asked Madison or Franklin, can you be subject to a tax or a penalty or any kind of government sanction for not doing something, for choosing just to be left alone? They'd have said, of course not. That's the kind of stuff we rebelled against.
Let me just quote Benjamin Franklin, as George did. Benjamin Franklin said, there are two things that are certain, death and paying taxes. We pay taxes whether we do anything or not. So, it's, I know you'll probably start with the economists. I can't argue the economic aspects of it. Sorry. You'll have to go to George.
Well, we do pay taxes, and oftentimes, like you say, on land, whether we do anything with the land or not. But we can't use that power to undermine the restrictions on the power of the government that are written into the Constitution. And that's exactly what's happened in this case.
Any other questions? Okay, I guess that will be all for tonight. Thanks for coming.